welcome to my channel. Please like, comment, and subscribe. Offshore Maritime Injury, Trans Act, Longshore and Harbour Workers Compensation Act, Maintenance and Cure. Trans Act. Attorney Walter Gabriel has long history in the courtroom, having served as both a prosecutor and as a Louisiana Trans Act attorney handling various injury claims. He has gained deep insight into the ways in which a dispute may develop over the course of litigation and how best to navigate the case so as to reach a favorable result in the United States. Certain qualifying seamen may receive compensation under the Federal Trans Act, also known as the Maritime Marine Act of 1920 for injuries they suffer while on the job. The Trans Act is highly protective of seamen's rights, and liability can give rise to full and adequate damages. As such, maritime defendants have long attempted to circumvent application of the Act. If you have been injured in a scenario that is likely to invoke maritime law, whether through the Trans Act or otherwise, we encourage you to contact the law firm of Walter Gabriel LLC for comprehensive assistance with your dispute. The Trans Act and its advantages. Under the Trans Act, employers must provide their seamen employees with a reasonably safe place to work. Failure to use ordinary care to maintain a vessel in a reasonably safe condition constitute negligence under the Trans Act. This negligence requirement is quite a bit less restrictive than the sort of negligence that the law requires to establish a cause of action in standard for personal injury litigation. However, as a claim may be actionable under the Trans Act so long as the employer's failure to provide a reasonably safe place to work contributed partially to the injury suffered by the employer. For example, suppose an improperly secured container causes your injury while aboard the cargo ship on which you work. Perhaps your employer, the shipping company, failed to adequately inspect and maintain the containers and their latches. The law requires this to ensure that the equipment was in its good working order. If your employer's negligence was partially responsible, then you may receive damages from under the Trans Act. This is true even if the negligence of the third party unloading the containers primarily caused your injury. Trans Act damages are not limited, as it's typically the case with traditional workers' compensation. Under the Trans Act, an injured plaintiff may sue and recover a range of damages, such as damages could include compensation for pain and suffering, medical expenses, lost wages, loss of future earning capacity, and more. Who is eligible for Trans Act compensation? Trans Act compensation is available to certain qualified seamen. The specific requirement area as follows. At least 30% of the seamen's working time must be with their employment-related vessel. The seamen's duties must directly contribute to the vessel's function or other related tasks, and the vessel must be in navigation, for example, floating on a navigable waterway such as river, ocean, or lake boundary, bonding to state or linked to a river or ocean, and able to travel without the assistance of a tool. For example, a worker who performs maintenance on ship once it has been broken into a warehouse would likely to not recover Trans Act compensation, but a crew member of a cargo ship that spends most working time aboard may receive Trans Act compensation. Contact an experienced Louisiana Trans Act attorney for a free consultation. The law firm of Walter Gabriel LLC is a personal injury firm representing the interests of those who have suffered harm in a variety of personal injury scenarios, including maritime injury dispute centered around a worker's right to compensation. Trans Act litigation can be quite complex. It's important that you work with a team of attorneys that has proved capable of handling such challenging disputes. Ready to speak to an attorney about your Trans Act claim? Call 318-445-2121 or send a message online to schedule a free and confidential consultation with the Louisiana Trans Act attorney at the law firm on Walter Gabriel LLC. Longshore and Harbour Workers Compensation Act. Louisiana Longshore and Harbour Workers Compensation Act attorney under the Longshore and Harbour Workers Compensation Act, or LHWCA. Longshoremen, dock workers, and various other qualified employees may receive benefits to compensate them for their lost wages, medical expenses, and rehabilitation expenses in the event they suffer on the job injury. Attorney Walter Gabriel has litigated challenging disputes in a variety of arenas. As a prosecutor and as plaintiff side's attorney, this experience does provide significant competitive advantages. This is because we are able to persuasively advocate for a person's position even when the opposing side has substantial resources at their disposal. Contact the law firm of Walter Gabriel LLC for comprehensive assistance with your LHWCA dispute. Available compensation under the Louisiana Longshore and Harbour Workers Compensation Act, the LHWCA entitles injured workers temporary or permanent disability benefit total or partial, compensation for reasonable and necessary medical treatment with physician of their choice, and compensation for critical rehabilitation services that help employee return to gainful employment, for example, counseling, retraining, job placement assistance, and more. If the injury contributes to the worker's death, the LHWCA provides survivor benefit that pay dependents such as the spouse who is eligible to receive compensation. Generally speaking, the employers covered by the LHWCA include any non-seamen such as longshoremen, builders, repairmen, cargo loading for workers, and harbor construction workers who suffer an injury that occur on navigable U.S. waters or on adjacent areas that are used for loading and unloading ships, for example, piers, docks, ship terminals, and etc. Even workers who do not fit the traditional maritime employee title may receive LHWCA benefits. This is so long as they regulate the job duties involve work at navigable U.S. waters or an adjacent maritime infrastructure, and their injury occurs while performing such duties. Mishandling of benefits. In many cases, opposing parties may deny, excessively delay, or undervalue mishandle LHWCA claims. If so, you may challenge the determination and recover the compensation that you deserve. For example, the law requires LHWCA compensation to coincide with the employer's average weekly wage before the injury. This calculation may be complete if it fails to account for the employee's promotion halfway through the year. If payout is based off incomplete or incorrect data, then your claim may be undervalued. In this scenario, you are entitled to challenge the lower payout. Speak to an experienced Louisiana longshore and harbor workers compensation at attorney compensation under the LHWCA may seem straightforward at first glance. However, complication relating to your claim could lead to unexpected denial and leave you in a vulnerable position. We can help. The law firm of Walter Gabriel LLC is a personal injury firm representing the interests of those who have suffered harm in a variety of scenarios, including injury or illness that affect the ability of longshoremen, dock workers, and other maritime employees to perform the regular duties of the job. Maintenance and cure. Louisiana Maintenance and Cure Attorney, founding attorney Walter Gabriel has period of experience in the courtroom, having served as a prosecutor and now as a Louisiana Maintenance and Cure Attorney representing those who have suffered serious injuries. This background affords us insight into how to navigate dispute to help our clients obtain the compensation they deserve. In Louisiana and elsewhere in the United States, commercial seamen injury while on the job may receive maintenance and cure benefits. These benefits function similar to workers' compensation benefits provided to shoreside workers. They are available under a similar no-fault scheme. This means that the law does not require the plaintiff to prove their employer caused the harm due to negligence. Instead, the law only requires the injured party to prove that he did actually suffer an injury within the course and scope of their employment. Seamen's right to maintenance. Maintenance benefits are calculated as a daily allowance that it means to cover the living expenses of the injured seamen during their period of recovery. In the past, many commercial maritime employers would include provision in the employment contract that allowed them to pay super maintenance benefit. But following a series of federal court decisions, employers can no longer rely on contract-based maintenance benefit. Instead, they must pay you an amount that reasonably approximates your daily living expenses. Punitive damages. If your employer pays out maintenance benefits that are substantially below the amount actually necessary to cover your daily living expenses, they may be able to issue and recover damages for the difference depending upon how egregious the conduct of the employer. The court may award punitive damages. Punitive damages multiply the compensatory damages amount and are intended to punish the defendant's right to cure. Cure benefit cover reasonable and necessary medical expenses. Seamen have right to compensation to cover medical expenses when injured within the course and scope of their employment. It's worth noting that seamen may not have their cure benefits terminated prematurely. The injured seamen must reach their maximum medical improvement before such benefits and timely treatment aboard vessel. The right to cure also extends to the need for timely and adequate treatment while aboard the vessel itself. If, for example, a seaman's injury occurs while working aboard a ship and the employer fails to secure timely and adequate medical treatment, this may give rise to an additional claims for negligence. Schedule a free consultation with an experienced Louisiana Maintenance and Cure attorney. At the law firm of Walter Gabriel, LLC, we have substantial experience representing seamen in maritime injury dispute against their employer. Seamen may receive a range of benefits that include maintenance and cure. In some cases, however, the employer may be hostile and unwilling to pay out an adequate benefit. Thanks for watching. Don't forget to like, comment, and subscribe.